So I'm going to share very briefly a somewhat of a chapter of my PhD, which considers post-conviction relief mechanisms in the United States and how effective those mechanisms are in light of the American innocence movement, i.e. the idea that over 300 people to date have been exonerated of crimes that they had allegedly committed. So my PhD really considers, theoretically, is the model of judicial decision making that judges use when looking at these particular claims. And a particular section of those claims are newly discovered evidence claims in relation to forensic evidence. So I'm going to take a look at how judges respond to those claims today and fit it in within two theoretical frameworks, namely finality and legal process theory. By way of introduction, my concentration is on the forensic identification discipline of firearms identification evidence. In particular, the alleged ability of that discipline to engage in what is known as individualisation, which is to everybody else the idea of matching a suspect weapon to suspect ammunition with 100% certainty. Now, that type of evidence has been admissible in American courtrooms for well over 100 years. It's very popular, quite like fingerprints, bite mark evidence, those sorts of things. However, in 2009, after a number of years of engaging with a variety of forensic disciplines, the National Academy of Sciences, which is the United States' premier organisation for independent expert scientific advice, after being commissioned by Congress to actually look into the veracity of one particular forensic science, which was firearms identification, they came to the conclusion that was actually no scientific underpinning to individualisation in any other forensic discipline than DNA typing. And the unprecedented conclusion, because there have been some grumblings about forensic disciplines, but in particular, the National Academy of Sciences report concluded that with the exception of DNA analysis, no forensic method has been rigorously shown to have the capacity to consistently and with a high degree of certainty demonstrate a connection between evidence and a specific individual or source. Now, I certainly don't come at my PhD from a scientific angle. I come at it from a legal perspective and seeing how judges react to these new scientific uncertainties. Unreliable forensic evidence was not new, particularly to those folks who are engaged in the innocence movement, because statistics show that in some way, shape or form, unreliable or faulty forensic evidence is responsible for about 49% of exonerations in the United States to date. But the report, the Nash report as we call it, was a landmark. They called it a blockbuster. And unsurprisingly, afterwards, defendants who had been convicted either in part or whole on the basis of, say, for example, firearms testimony, started to use the Nash report as a new piece of evidence to challenge their convictions. So they used the report to bolster their appeals. And one way that they have done this is by presenting it in a newly discovered evidence claim. And the way that they couch their argument is by saying that the Nash report demonstrates a shift in scientific opinion around firearms testimony. And on that basis, the conviction becomes vulnerable to challenge. Now, when using these particular rules, these newly discovered evidence rules, there are generally a couple of general requirements across the states. No state rule is ever the same, but they generally have a need for the evidence to be new, so it must have not been found before trial or been open to being found before trial. You had to find it with what they call reasonable diligence, so within a certain amount of time. It has to be relevant to the question at hand and not merely cumulative or impeaching, so just attacking credibility. And it's got to have what they call verdict-changing capacity. So in other words, when it comes to forensic identification evidence, the Nash report and the criticisms within it need to show that if the jury would have known about this scientific controversy, then it would have changed their minds, in effect. That's what it needs to show. And part of my PhD looks at how judges have reacted to these claims. Now, altogether, all of those criteria come together to make a very high threshold to meet. Post-conviction is a labyrinth of complex procedures, and they bear what I term as the hallmark of finality. Finality being the need to close things off. So just to summarise judicial trends, it really comes as no surprise, but when faced with challenges or newly discovered evidence claim based on the Nash report, judges have resoundingly rejected them, saying that in particular we would like to defer to the trial court decision that allowed this evidence in and gave it to the jury to consider. And secondly, that we don't actually consider that the Nash report is new evidence. And the two main reasons for them doing that was because the Nash report cited to various criticisms in the past, some dating back to the 1970s. Furthermore, they said, defendants have not zoned in and actually shown how the Nash report has affected their particular case, because the Nash report was not written for them in particular. So that is the argument that judges have been put forward. So my question is, why are they doing this? And really, in my view, there's two answers. The first is that they are closing things off because of finality. Appellate judges in particular have a duty to close eventually the appeals process. They need to conserve state resources, they need to find repose, they need to engage with all those various interests. But also, they are ticking off that just because there has been no legal error, they're unwilling to look at factual error, which is indicative of them searching purely for procedural regularity and not substantive justice, which for the lawyers in the room, you should know, is a classic tenet of legal process theory. So, just to expand on those things a little bit more, so the doctrine of finality is usually the reason why judges close everything off. It's made up of multiple different issues that are at stake if we allow an appeal to keep coming back at us. Of course, there's not only problems for the state, so you waste resources, you are telling lawyers that they'll keep getting multiple bites at the cherry, but there are things to consider for the defendant too. They don't want something to continue. But finality has this tradition of trumping substantive issues, and it appears that it is doing so in this case too. Legal process theory plays a role in that. By the appellate courts just looking for legal error, seeing if counsel did an effective job, seeing whether or not there was a proper disclosure, all the rules were followed. They are simply looking for procedural error. And they look for what Wallet calls a failure of process. But he says this fails to take account of the fact that factual things can go wrong. And in particular, the innocence movement has shown us that. Just to finish, and this is the angle that I'm going to take my writing on now, is that this has made me consider why the courts are paying little what we call deference to the National Academy of Sciences, because they are a premier authority on scientific issues. So in effect, why have they told them to swivel and we don't care, despite the fact that we know Congress commissioned you to look at this issue? So I'm going to take a look at deference, and I'm also going to take a look at institutional competence. Legal process theory says that every institution has a particular role and particular questions to answer. And if we allocate the right questions to the right institution, then everything should work out hunky-dory, in effect. And I want to now take my research to further consider the question about where is a court's institutional competence for making scientific decisions, particularly when there is a real dearth of scientific expertise when it comes to lawyers, except Hayden, of course, who's a scientist. That's it, so thank you.
Thank you, sir. Are there any questions before we move on to the next session?
Yeah, I've got a question. How do you explain the fact that in a lot of American cases involving environmental law, for instance, there's an almost sort of hysterical deference to technical experts who come into court and talk about, toxicity of ocean or fish and so on. And yet in this case, they appear to be doing the exact opposite.
My initial reaction is, and I'd have to check this, is because those experts will be appearing on behalf of an agency, usually a federal agency, I imagine. And there seems to be a distinct difference between how the courts treat a federal agency representative and how they treat the National Academy of Sciences. And I'm trying to figure out why does the National Academy of Sciences, because technically it's more independent than an agency, a federal agency, why are they not giving deference? And to be honest, I don't know the answer yet, but that's something I'm looking into. Yeah.
You started talking about DNA of the bullet and then NAS virgin. Was there any similarities between the two? Because one would imagine that there should be, and hence there would be no difference to the final outcome of the cases.
I'm sorry, so
you started off by talking about the individual bullets going through a gun.
yes.
Yes. Surely there should have been high similarity with the scientific results, but that wasn't the case.
Well, the real question, or the legal question now is about how we allow an expert to describe that. So, for example, most experts historically have been saying, through my experience and training, I can tell you that I'm 100% certain that that fatal bullet came out of the shaft of that gun. However, what the National Academy of Sciences found was that statement has no scientific underpinning, and they said that it's not possible, but until we have sufficient database to tell us that, for example, there is actually a 1 in 350 chance that that bullet came from that gun, then we shouldn't be allowing experts to testify in such definite terms. And it's been, what I'm taking a look at is actually how slow the courts are, or willing the courts are, to respond to that step back from absolute terms. So it may actually be the case that there is, a high probability that the examiners are correct. It's just that there is a scientific concern that they're not presenting it in the most accurate way.